And welcome to this meeting of the Randwick Local Planning Panel. I'd like to begin by acknowledging the traditional owners of the various lands we occupy for this meeting, the Aboriginal people, their spirits and ancestors. We pay our respects to elders past and present. The public meeting today is to consider the determination of two applications, a development application and an application to modify an existing development consent. We will deal with them in the order shown on the agenda. The panel members for today's meeting are myself, Lindsay Fletcher, as the independent chair, Julie Savitt-Ward and Peter Romme as the independent expert members, and the community member is Michelle Finnegan. This meeting is being held by public video conference due to COVID-19 precautions. As the panel chair, I'm requesting that you be considerate and respectful of each other and remain on mute until I ask you to speak at the meeting. I also request that none of you interject while another person is speaking, otherwise I will have to request that you're no longer part of the meeting. The panel operates in terms of a code of conduct and operating guidelines, which have been modified to facilitate the effective functioning of this panel. Temporary changes are available on Council's website. This public meeting will be recorded and will be placed on Council's website following the meeting. If that is of concern to you on privacy grounds, then I suggest you take it into consideration in your decision to make a public statement before the panel today. In terms of the code, general declarations of interest have been provided before the meeting by all panel members, as well as a specific declaration of interest in relation to matters being considered today. Could I ask members of the panel to just confirm that they have no conflicts of interest?
Julie Savitt-Ward, no conflict of interest.
Peter Romme, no conflict of interest.
Michelle Finnegan, no conflict of interest.
And nor do I. So the signed declarations of interest will be available to view through the Council's website by tomorrow afternoon. I also wish to advise that all members of the public addressing the panel today must declare, prior to commencing their address, any political contributions or donations made over the past 2 years, exceeding $1,000 to any political party or candidate who contested the last ordinary election of the Council. Our usual practice is to allow each speaker 3 minutes to present, including speakers representing community groups, individuals, and the applicant. If you have registered to speak, your address to the panel will be recorded. You'll be given a warning about 30 seconds before your time limit. And I do have a limited discretion to allow extra time if appropriate. Our usual practice is that we will hear first from any councillor that has registered to speak, followed by members of the public, and then from the applicant in each case. The panel has been provided with a copy of all the submissions received in response to the public exhibition of both applications. Therefore, there is no need for speakers to repeat points made in those submissions. I ask that each speaker be heard in silence while they are addressing the panel, and that courtesy and respect be observed throughout this meeting. There is to be no personal criticism directed at any speaker or council staff. Any such criticism would be contrary to the panel's code of conduct and will not be accepted. Panel members may ask questions of the speakers after they've addressed us to clarify our understanding of what has been said. After hearing from all the speakers, the panel will adjourn to debate the matters and to make its determinations. If more information is required by the panel, that decision may be deferred either for a further public meeting or to be dealt with at an electronic meeting. The panel decisions and recording will be made available on the Council's website as soon as possible, usually the following day. There is to be no recording of this meeting other than the official recording. Okay, so the panel will now consider the matter of development application 367 of 2019 for alterations and additions to a dwelling house at 59 Beach Street, Coogee. I have 5 people registered to address the panel on this matter. And I will now invite the first speaker to present. That is Councillor Lindsay Shuri. I hope I've pronounced that correctly. Before speaking, please say your name for the benefit of the recording and indicate whether you have made any relevant political donations. Councillor Shuri.
Thank you for allowing me to speak. My name is Lindsay Shuri. I'm councillor for Randwick Council North Ward. I'm also speaking on behalf of Councillor Nielsen today to save you time, as we both agree on this particular point. I have made no political donations, nor have I received any political donations since the last council election. My main concern is the trees on the property, and although there isn't a clause asking or a condition asking for those trees to be retained, basically because the developer hasn't asked for the trees to be taken out, but to assure for the privacy of the neighbours, I would like a condition in that approval, if that goes ahead, that no trees on the site can be removed, just to give that extra security for the residents in the adjoining residents. That's it.
Thank you, Councillor, and we will obviously take that on board. Thank you.
Thank you.
The next speaker I have is, again, apologies for the pronunciation, but Ms. Litza Andreas. Andredias, I think.
There might be an error there. It's Michael Miclandos. Litza Andreadis was going to speak in case I couldn't speak, and the pronunciation of my name would have been far more difficult. Thank you, panel members. I'm the owner of Unit 456 Beach Street, Coogee. I'm also speaking on behalf of the other owners of the other 3 units, including Litza, on 50 Beach Street. That's units 1 to 11. Each of them requested the opportunity to address the panel today, but have been notified that that was not possible, and I'll do my best to address their interests. The key issue in respect of Unit 4 and Unit 3 is that despite the recent amendments to the development, we still lose significant views, which we enjoy from our balconies and living areas, particularly of the land and water interfaces. These views can only be enjoyed by residents from one aspect, which will be significantly affected by the development. This aspect is only from the balcony of each unit, which is a private open space and adjacent living areas. If the development is approved in its current form, then our views will be limited to distance and horizon views. It is the land and water interfaces which really are of significant visual interest to us. Please understand that these views are highly valuable to us and the unit amenity. My retirement plan, in fact, involves sitting on my balcony and enjoying these views. To say the least, this development and its various incarnations has caused a lot of upset. What has been particularly upsetting is that the original application and second amended application appeared to misrepresent the impact on our views. It stated they were minimal when in fact that they were devastating. It therefore mystifies us as to why we didn't receive proper notification of this third incarnation of the development. The council first notified us of these amendments on the 17th of November, which was about a week ago. The amended plans were supposedly lodged on the 29th of October, but didn't appear on the council's DA tracker when we received the notice of meeting. When queried, the council told our representative, William, who will be speaking a bit later, that this was essentially because no re-notification was required because the amended plans involved a reduction in height. We've therefore been denied the opportunity to issue requisitions in relation to the new plans. We then receive a detailed 85-page report from the council only 5 days ago. You would have expected a more reasonable consultation and notification process. However, there's been little transparency or a duty of care shown to us. Instead, we've been left scrambling to review and understand this third round of amendments within a very short time frame. Certain statements are made in the report as the impact of this amended development on views relying on photo montages provided by the applicant. It is not clear what photos are relied upon, where they were taken, and whether multiple viewpoints were taken into account. There also appear to be some errors in the report. On page 22, in relation to the view from our balcony, that is unit 456, it's stated that this view is moderate, given that it contains a view of interfacing land and water views. However, it is very close to the existing dwellings.
Can I
Yes.
interrupt you for a moment, because you're rapidly running out of time? I am prepared to give you an additional minute,
Sure.
but ask that you hopefully wrap up in that time.
That should be enough. It says that the view is obstructed by trees, but the photo provided is very poor. I've issued a photo which hopefully panel members have received, and as you can see from that photo, the trees don't obstruct the land interface at all, but actually obstruct other buildings. A request for height poles is made to determine the view loss, but these were never installed. The photos in the report are poor. It's difficult to discern key landmarks or judge the impact of views. We have legitimate concerns, particularly because the prior applications misrepresented the impact of the development of our views. What is also clear is that even if we accept the accuracy of what has been filed, the development still exceeds the height limit. The development still has significant impact on views, in particular views of headland and the interface. These views are valuable, they're cherished, and they're well established, and there's no justification for a breach of the height limit in these circumstances. So in summary, we request that the proposal should not be approved, but the development should be more sympathetic to the street. This can be done by pushing the mass on the upper level from the facade of Beach Street to the lower level, that the applicant should comply with height requirements. The applicant should be required to conduct a proper view analysis, and this should be shared, and we should be given a proper opportunity to review the amended development.
Thank you.
Thank you.
Can I ask panel members whether they have any questions of the speaker at this stage?
Not from me, thank you.
Not from me, thank you.
Okay. So
I did want to check if the photo was received.
Yes, I can confirm that we have received that photo. So thank you for that.
Thank you.
The next speaker I have is Mr. Stuart Murray, also speaking against the application. Mr. Murray, are you there?
Yes, I'm here. Thank you very much. I'd like to reiterate what the last speaker just said. I thought it was very well spoken and you made a lot of very good points, so thank you very much. Now, my name is Stuart Murray. I live at 6 Gordon Avenue, Coogee, next door to the northern side of the applicant for 59 Beach Street, Coogee. As shown by the video shown to the panel members earlier today, this DA will significantly impact negatively on our living lives and living spaces. It will change the way we live and the way we feel about our living in our home. This structure towers above us already, and it is only 2 stories high. It will tower over us even more if it is allowed to go to 3 levels. It will feel like a 3-story block of units on top of us. We won't feel comfortable with someone looking over us from 3 stories above, and nor would I imagine anybody else. This DA is non-compliant areas, impacting significantly on our lifestyle and our privacy. The wall height, the council's maximum allowable height is 8 metres. This DA has a wall height of 9.3 metres. The building height, the maximum allowed is 9 metres, and this DA goes to 9.2 metres. As well, the size setback on the northern side is not enough at this height. The extra bulk created at this new 3rd height will be very intrusive in our backyard. This will also make it feel like this building will be towering over us. This 3rd level should be stepped in considerably to provide relief. Windows 26, 27 and 28 look right into our backyard and offer us no privacy. They should be frosted windows or perhaps even removed. We have created our own privacy through the planting of bamboo trees. They can't grow much higher than their current levels. How does the applicant propose to screen out his 3rd level with plants? It's not possible at this height unless he trucks in mature 20-metre high trees. The 2 balconies on the eastern side will also tower above us, looking into our living room, kitchen, and my children's ground floor bathroom and bedrooms. We do not feel comfortable about this one single bit. The balcony privacy screens are completely inadequate and offer 0 privacy, as they only go 1 metre along each balcony. They need to go along the entire depth of each balcony. Even then, someone standing on the edge of each balcony in the middle will still be able to look down into my children's bathroom and bedrooms, rendering these privacy screens redundant. We ask that you please don't let this happen. There are mature trees on the applicant's property which provide considerable noise, and site privacy for our living spaces. These trees are not covered under the RDCP and may be removed without development consent. I fear that they may die or be cut down without consent, impacting on our privacy. This is the wrong site for a DA like this. Our house is lower down than Beach Street, and we are one of 3 houses with dual access from Gordon Avenue to Beach Street. It's a unique setting. We ask that you help to preserve this unique setting within the community. To approve this DA is not right. It will disadvantage our family. Yes.
Mr. Murray, sorry, your 3 minutes is up, but I'm prepared to give you an additional minute if you could wrap up in that time.
Thank you. I'm just wrapping up now. Thank you. Please do not let this happen. My wife and I have created a good, safe and private environment for our kids to enjoy. Please don't allow the applicant to take this away. We are not opposed to development by people who wish to improve their own lives and property. However, this improvement should not come at the expense of other people. We do have conditions, and this is the chance to do it. We don't want this to be approved. However, if it is approved, we'd like to put on record that it's approved with the following conditions: that windows 26, 22nd and 28 all be removed or at the very least be frosted. The trees on the applicant's property must be replaced with similar size mature trees if ones die or are removed. Balcony screens need to go all the way across each side to provide adequate privacy. An independent dilapidation report is done prior to demolition and commencing building. Noise concerns are limited while building. While willing to consider some parts of the current DA, if the 3rd story is stepped all along the northern side, thereby reducing bulk. And finally, a dust noise barrier is erected between our houses before demolition to prevent dust and debris going all over our white house. In closing, I appreciate the opportunity to speak at this panel meeting. I trust the panel will make the right decision for us and the community and not approve this DA. Thank you.
Thank you, Mr. Murray. Members, any questions?
Mr. Murray, I had one question. Sorry, Mr. Murray, one question for you. You initially mentioned the balconies on the eastern side, but in your suggested condition, is it all balconies that you would prefer to have screens across each side, or just the eastern balconies?
Oh, look, I'm referring to all balconies that are there, certainly on the eastern side. There will be 2 balconies that will look into our side passage, that is living room, kitchen, bathrooms and bedrooms. A 1 metre wide privacy screen will do absolutely nothing. So I'd like them to go all the way across. Even then, I still find them redundant because the position of the balconies, particularly up high, someone can walk right in the middle of the balcony and still look down into our bedrooms and bathrooms, and it's not right. And that's really why I wanted to get the panel members to come into my property and have a look and see it for themselves. And I know this wasn't possible, but if the panel members were able to come and visit from my property, there is no way they would allow this approval to go ahead because they wouldn't want this to happen to their own property. And that's what I found the most difficult thing about all this, is that the applicant has had 1.5 years to prepare for this. We've had since the 17th of November. It hasn't been a fair process.
Yeah,
Thank you.
I think we acknowledge the difficulties that COVID has provided, certainly affected the way we operate as a panel, because normally we would have been able to visit your property and indeed the subject site and hear from the applicant, but that's not possible. Yes. I do say that we could at least see the area, your rear, I think you call it your rear yard, area that you're particularly concerned with. We could see that from the street. So it's not the same as being in there, but we have an understanding, I think, of the point you've made in your submissions. So thank you for your submission. Any further questions from the panel members?
Not from me.
No, not from me. Thank you.
Okay, thank you. So thank you
very much,
Mr. Murray. The next speaker I have is Mr. William Fleming, also speaking in opposition to the proposal. Mr. Fleming.
Yes, thank you, Chair. I'm speaking on behalf of the residents at 54 Beach Street, which is across the road, the apartment building.
Yes.
Firstly, I just want to say that we do not believe that the applicants have adequately demonstrated consistency with the zone and building height objectives within the LEP due to the significant view loss that is associated with the proposed development. And as such, I believe that the clause 4.6 is considered to be inadequate in this case. In particular, with regards to their environmental planning grounds justifications, they say in their clause 4.6 that, quote, measures incorporated into the proposed alterations and additions will protect and improve the amenity of residents beyond that associated with the existing dwelling house on the site, which I believe is an overreach of interpretation there. The focus of the objection is based on view loss at 54 Beach Street. We do not agree with the view loss assessment undertaken by council, nor that the development is reasonable. On page 12 of the assessment report, with regards to the previously amended plan submitted in May, the assessing officer determined that the obliteration of whole views was reasonable to units 3 and 4 due to the fact that they are located on the first floor. It is unclear as to why the location of these units within the apartment building, which is situated on the high side of Beach Street, don't have a reasonable expectation to retain these whole views. The fact of the matter is that units 3, 4 and 5 will have these whole views either obliterated or significantly reduced as a result of the non-compliances to building height and wall height. Council have determined that they believe the reduction or obliteration of these whole views is acceptable due to the retention of the horizon water views. The planning principle clearly states that whole views are valued more highly and that the retention of horizon water views is of little comfort to the residents of 54 Beach Street. The loss of the ability to view the activity of the bay with surfers, swimmers, boats, as well as being able to enjoy the big swells that roll in and smash into the cliff face, forms a significant part of the enjoyment of living in this apartment building. The balconies are located at the front of the site, views, with Unit 4's balcony being associated with their primary habitable kitchen and living area. With regards to step 4 of the planning principle, we do not agree with Council's acceptance that the design is reasonable given the impact to these whole views. While it is acknowledged that the applicant has reduced the overall building height from the original scheme, the non-compliant overall height and the significantly non-compliant wall heights still result in unreasonable view impacts. With regards to a more skillful design approach, little attention has been given to the northern elevation wall height, which is grossly above the 7-metre wall height, which I think should be applied. Or if not, it's grossly above the 8-metre steeply sloping wall height control within the DCP.
Yep.
Compliance with the overall...
Fleming,
yes.
Sorry, you've exceeded your 3 minutes already. I'm happy to give you, as I have the others, an additional minute, but I'm hoping you can wrap up within that time.
Yes, I'm almost there. It won't be long. Compliance with the overall building height could be achieved and still have its 2-storey presentation to the street. In that regard, I do not accept Council's opinion that further reduction of the overall height and wall height would result in an inordinately reduced scale within the streetscape that is well below which exists already. The preservation of amenity of the proposed upper level should not come at the expense of the reduced amenity of the surrounding development. Amendments to the northern elevation wall height, such as stepping it in further from the side boundary, as spoken about by Stuart Murray, would assist with preserving view corridors down to Gordon Bay, as well as providing much needed relief to the visual bulk when viewed from 6 Gordon Avenue. Lastly, the development potential of a site is derived from existing constraints and features of that site. The undersized nature of the lot nor whatever the pre-excavated topography of the site was, should be considered justification for increased floor space by going up and breaching the building height controls despite being compliant with the FSR control. That's all I have to say.
Thank you for that, and apologies if you're hearing the noise in my background, but hopefully it'll go away. Panel members, any questions of Mr. Fleming?
I have no questions.
I have one question, Mr. Fleming.
Yeah.
In your view, what would you say? To what degree do you say that the northern wall height exceeds the control? You mentioned 7 metres and or 8 metres. Can you just sort of clarify what you see would be the statutory complying wall height there?
Well, it's a DCP control, so it's not a statutory control.
The DCP, sorry. Mm.
Yeah, so the DCP says that a 7 metre wall height should apply to sites that are of a gentle gradient or relatively flat. And in my opinion, the topography of the site has been modified significantly so it isn't a steeply sloping site anymore. And so a 7 metre wall height should apply, but both the applicant and council have determined that because the site steps down approximately 3 metres from street level straight down, that determines the site to be a steeply sloping site. And the DCP doesn't say sloping site, it says steeply sloping site. So I can't see how this could be considered a steeply sloping site where an 8 metre wall height would apply.
Okay. Thank you very much.
Thank you.
Thank you. Any other panel members? So it seems not. So thank you, Mr. Fleming, for that. The final speaker I have listed on this item is Ms. Elani Mvalamas. Again, apologies if that's not the correct pronunciation. You're speaking on behalf of the applicant, I understand.
Yes. Good afternoon, panel and chair. My name is Eleni Mvalonis, and I'm a town planner representing the applicants of this DA. I refer to the council's planning assessment report, which initiates that consent be granted to the proposed development, as it satisfies the objective of clause 4.3 of the Randwick LEP and sections 4.16 and 4.17 of the EP&A Act. As representatives of the applicants, I strongly support the proposed development with the amendments made as per council's recommendations, and also agree that it be approved. Regarding view loss objections, 4 skillful amendments have been applied to the proposed development in order to fulfil comments proposed by council staff addressing the concerns surrounding view loss, bulk and overshadowing. The reduction in height and floor area of the proposed upper floor has resulted in a decrease of the initial floor height to 2.4 metres. Further height reductions are not possible without completely removing the upper floor, which would severely restrict the development potential of the site and will not align with the character of properties along the south. In addition, these amendments further satisfy the planning principles established under Tenacity Consulting versus Warringah. We ask that the panel consider removing 2 conditions, the first being 2A for the privacy screen along the south side, as the existing fence is approximately 3 metres high, and the second condition being 2B for the northern windows, Windows 26 and Windows 27, as they are appropriately located and do not provide any direct viewing into neighbouring habitable areas as per the Randwick DCP. In addition, the existing 4 metre bamboo screen that limits viewing into the existing rear yard, which is not very private, can be viewed from the existing streetscape. Therefore, the proposed addition will not adversely affect the amenity of this area. Our clients would like to welcome the opportunity to clarify and address any concerns and highly support Randwick Council's recommendation for approval.
Thank you. Is there any questions from panel members?
Yes, I have a couple of questions, if I may.
Please, yes.
First of all, it's just a point of clarification. There was quite a bit of crackling in the background noise. Can you clarify what you said about conditions 2A and 2B, please?
Yes, absolutely. So regarding conditions 2A,
Yes.
asking that screening along the south side is 3 metres high. By removing this condition, the 3 metre high wall will essentially is essentially an existing feature of the property. And with condition 2B, the northern windows, we believe that they're appropriately located for where they are, and they don't provide any direct viewing into any habitable areas of the neighbouring site.
And so you're saying you don't think they should be a minimum sill height of 1.6. Is that what you're saying?
Correct. That's correct.
Okay. Thank you for clarifying. The objectors have raised a number of issues that I'd like if you could specifically respond to, namely the wall height, pushing the mass back on that upper floor back towards the rear of the property, and stepping in the side boundary, I think on the northern side. Could you specifically respond to those issues, please?
So in regards to the maximum wall height, there's an existing 2.4 metre setback on that side. So, sorry, an existing 2 metre setback on that side. Therefore, with that existing setback, we don't believe that any it will affect any further amendment to that property on the neighbouring side, just because it is existing. In terms of the setback of the bulk further back to the site, we believe by doing this, it will misalign the character of the area. And by doing this, we believe that the proposed development essentially aligns with the existing character of the site. So by setting it further back, it's going to misalign with it.
Can I respond to that?
We do have our applicant here who would like to say a few words in response to that, if that's okay.
Good afternoon. I hope you can see me. My name is Peter Ong, and I'm the owner of the property of 59 Beach Street. To respond to your question, I think the wall height, in terms of wall height, it responds appropriately to the site conditions, and it's of a similar character to all the neighboring properties along the south of that. It sits in quite well with the character of the neighborhood. In terms of the setback, it's probably about 1.99 meters, which is, I understand, which is more than a council's requirement, and that would sit very well with council's recommendation as well.
Can I just ask, was Mr. Ong registered to speak at this meeting?
Sorry, Mr.
Was Mr. Ong the owner of the property?
I asked to register, but they say that there's only sort of one connection. So I'm sitting in with my town planner who's representing.
No, I think it's one speaker.
That's true, but he was responding to a question. Okay, any further questions from panel members?
So yes, thank you, Chair. So are there the side setback on the top level? The objectors were making were suggesting that to increase the view corridor, to have a setback on that top level, not the wall height per se issue. Is there any response you have to that particular suggestion?
It would be.
I think we should hear from the registered speaker if we can.
So essentially, in this instance, previous amendments have been made to this top level. Any further amendments that will be made essentially will lessen the development of this proposed development essentially. So by reducing that, we're essentially proposing for ultimately a smaller space, and which we've already made amendments to.
Okay, and then my additional question is that there was a suggestion that all trees on the subject property be retained, given that they are trees that aren't listed on council's policy and therefore they can be removed at any point. The suggestion was that there be a condition of consent to actually retain those trees. What's your response regarding that one?
So essentially the lower ground floors and the ground floor has been reduced. So we believe that by retaining these trees, it won't make any significant impact really, just because we've already made amendments to those lower ground floors and ground floors.
So I'm sorry, to clarify, you're comfortable with that or not?
Sorry, we haven't actually considered that yet. It's a bit further down the road. But the point we're trying to make is that the existing windows has been reduced in size on both the ground floor and lower ground floor. There's no possible viewing from those into any habitable area of the northern neighbour.
Right. I believe the question relates to the trees. Your documentation indicates that the trees won't be removed. So the assumption is that they are part of the proposal to stay. However, because they are trees that aren't prescribed by council, they could be removed. So in terms of screening and privacy, they form part of the proposal. So I'm just seeking a response on that issue.
Essentially to confirm that you will retain them.
If we do remove the current trees, we would replace them with the bamboo screening similar to the neighbours. We haven't made any decision on that yet because the trees now are very deciduous, so it leaves a lot of leaves and maintenance requirements is very high. But if we do remove those trees, we'll put bamboo screening similar to what they got on the northern neighbours.
Okay, thank you.
That's all I have. Thank you.
Thank you. Any questions from other panel members?
Chair, I have one final one, which is for Miss Amvalonis. Sorry, I hope I have that right. You were proposing to amend condition 2A, or to remove condition 2A, is that correct?
Yes, that's correct.
In entirety?
Yes, in entirety, yes.
And you said, if I recall correctly, that condition wasn't required because there are other elements such as walls that limit the are already doing the job, I suppose, of what the privacy screens would do.
That's correct. So the 3 metre high wall, the existing 3 metre high wall, we believe that already provides adequate screening on that side. So by adding any additional screening, it won't make any significant difference.
But that's at what level is that? Is that the existing ground level you're talking about?
On the existing ground level, yes.
And what about the upper level?
We've got no issue.
With the upper level, that's fine. We have no issue with the upper level.
Okay. Thanks very much.
Thank you.
Any other panel members? No? Well, I have a question for the planner, and it's in relation to the clause 4.6 and your obligations to demonstrate compliance with the objectives. You assert that the proposal complies with the objectives for the standard, but in the documents I've been provided, I haven't seen anything that actually demonstrates that fact.
Regarding height?
The height variation, yeah, the variation you're seeking. You need to demonstrate, not just assert, that it complies, that it satisfies the amenity objectives of the standard.
Essentially, within the clause 4.6, we understand that it doesn't comply with council's regulations. But what we're proposing is that the height itself, if reduced, won't comply with any BCA requirements. So if the height is reduced any further, we won't meet those requirements essentially.
Is that a consequence of alterations and additions?
Correct, yes.
Okay. The extent of the alterations are very significant. In fact, it would seem potentially not consistent with the planning principle on how this should be treated. There's concessions being sought and supported by council staff in terms of some setbacks in that regard, but obviously the height's the other one. I mean, if this were treated as a new development, I dare say it would be possible to fully comply, would it not?
That's correct, yes.
So has that been considered? Why would you not consider full compliance?
So in this instance, we're considering this non-compliance just because that we believe that by making any further alterations than the ones that have already been made, essentially we wouldn't fulfill the development potential of the site, and essentially we wouldn't be able to comply with the characteristics of surrounding properties, essentially by as well as the BCA. So if we reduce the height by any further, we won't be able to comply with the BCA. And neighbouring properties along Beach Street, along the south, essentially there is no consistency in terms of height or design per se, just because of that slope that the street does have.
Okay, and where is that demonstrated in your clause 4.6?
Essentially, within clause 4.6, if I just give me a moment to bring it up.
Well, in the clause 4.6 or other documentation. I mean, it's I know it's asserted in the clause 4.6, but I haven't seen yet where it's actually demonstrated that you satisfy those objectives.
So essentially, within...
excuse me, Mr. Chair, sorry to interrupt, just while the planner is looking that up. Councillor Roberts has requested to speak against 9 Carlton Street later. Would that be acceptable?
Yeah, that's fine. Thank you. So Councillor Roberts, is it?
Yes.
Thank you.
Thank you, Chair.
Okay, looks like we've lost our speaker anyway. If there's...
Still here.
Councillor, with permission, can I speak? I'm the owner. Yes,
well, no, the question's really directed at your planner, who presumably prepared the clause 4.6.
So I'm speaking on behalf of my colleague who prepared 4.6. So I'll refer back to it. So essentially within clause 4.6, sorry, just bear with me for a second. So essentially we refer to the clause 4.6 in section 5, which section 5 and objective B. So objective B states to ensure that development is compatible with the site, with the scale and character of contributory buildings in a conservation area or near a heritage item. So essentially, we demonstrate within this table that surrounding sites pose similar levels of density and levels of development.
I'm more interested in objective C, which states the development results in no unreasonable adverse impacts on adjoining properties. I've heard from the adjoining properties. Where have you demonstrated that there's no adverse impacts or no unreasonable adverse impacts?
So no unreasonable adverse impacts essentially can be seen within the the amendments that have been made to the height of the building. So we have reduced the height quite significantly from the initial proposal. And we believe that this new proposed height of 2.4 metres doesn't pose any substantial overshadowing to neighbouring properties.
Where is that demonstrated?
So that is demonstrated within the amended drawings as seen within the shadow diagrams.
Okay, thank you. So no questions arising from other panel members?
I have no further questions, thank you.
Thank you, nor do I. So that concludes that item. We will now, and thank you to our speakers on that. We will, as indicated previously, we will, after hearing speakers on the next item, we will close the meeting and then move to a separate meeting to deliberate, and our decisions will be announced on the council website. The second item is development application, a modification application for changes to an approved residential flat building at 9 Carlton Street, Kensington. I have now 3 speakers registered to speak. The first of those is Councillor Roberts, and I might just remind those speaking that before speaking, please say your name for the benefit of the recording, and also indicate whether or not you have made any relevant political donations, those being donations of more than $1,000 to any political party or candidate who contested the last council election. So, Councillor Roberts. Is Councillor Roberts there? I've got a hot desk.
Hi there, I'm really sorry to interrupt. This is Councillor Philippa Veach. I think there's been a mix-up. It's actually a local resident, Brendan Horry, who is registered to speak.
Yes, he is.
Not Brendan Roberts. I'm not sure if Councillor Roberts is here, but there's been a flow of emails and I believe that there has been a mix-up. It's actually, I believe it is Kensington resident Brendan Horry who registered to speak a couple of days ago. Yeah, if Councillor Roberts is here, I do apologise, but I just wanted to clarify that.
I have Mr. Horry listed to speak, so I was going to move to him next, but I understood that Councillor Roberts did wish to address us. If Councillor Roberts isn't there and that's not the case, we will move on to Mr. Brendan Horry, who is registered to speak as an objector to the development. Mr. Horry, are you there?
Yes, hello, just testing. Can I be heard?
Yes, we can hear you clearly. We can't see you, but we can hear you clearly.
Right, I'm just at work, that's all, so it's not great. Yeah, so it's only a quick one. I sort of realised that this development had already been approved by the Land and Environment Court, and that this sort of DA was just to sort of modify it. Unfortunately, I'm a local resident, and I was not living in the country at the time when this went to the Land and Environment Court. Otherwise, I probably would have suggested to council to seek an interim heritage order, because I do believe that this building has architectural value, and it has value in terms of showing sort of how Kensington was at the turn of the 20th century. There's very few buildings similar to this. So this is a Federation mansion, which has sort of elements of the arts and craft movement that sort of came over to Australia from the UK. And I think, I failed to sort of understand why this building wasn't registered back in 98 or 2002 when the last review was done. So it's quite a great shame. And I just there's enough precedents within 100 metres of this house, such as 2 to 4 Carlton Street, 25 Doncaster Avenue and 58 Doncaster Avenue of a similar sort of architectural merit, which are in the Schedule 5 Randwick LEP. And so, based on, when you look at this sort of house at 9 Carlton Street and compare it to the precedents of houses within 100 metres, one just really struggles to understand why it wasn't registered already. And I think sort of Randwick City Council has a responsibility to future residents to make sure that sort of the few remaining houses that we have that sort of date back to the turn of the 20th century when the early subdivision of Kensington was taking place, that we don't lose these few houses. And I mean, that's sort of where my concern is, just in terms of losing the character of Kensington for future generations, and just having an entire sort of area demarcated by Allison Road, Doncaster, and Anzac Parade as all sort of tiny little apartments. And I think it's a great shame that council hasn't done more. And I think at this stage, that was what my major concern was.
Thank you, Mr. Horry, and that's reflected in most of the submissions that have been received. This panel, though, is not the council; it's an independent panel, and we don't have any say in formulating the planning controls. That is, as you rightly say, a matter for the council. Unfortunately, there are a number of councillors listening in, so in that sense, participating. I'm sure they hear what you have to say. Our task today is to assess the changes involved. We can't go back and withdraw an approval that's been granted. So just to clarify, I believe you're not an immediately adjoining resident. But
no, I'm not. No, I'm
no criticism there. I understand your concern.
Yes.
But there's nothing specific in the changes proposed that is of concern to you. Is that correct? It's more the fact that it's
there are some other issues in terms of the. I mean, these are issues. Sorry, can I still be heard?
Yes.
Oh yes. Yeah. I mean, there's issues that don't directly affect me, and I think the apartment next to it, on the sort of eastern elevation, the ground floor apartments won't receive any sunlight as a direct result of this. And the architect or the developer has made an argument that, but it's only the bedrooms and the bathrooms and not the actual living space. And so it seems like there's a few sort of loopholes where they've tried to justify a development that isn't really a great outcome for the suburb, really. I mean, there's a lot of overshadowing. I'm sure a lot of you have looked through the DA and seen the overshadowing, even for 7 Carlton Street, which is the terraces next to it on the eastern elevation. I'm surprised that those residents haven't sort of spoken up more, or whether they're just sort of blissfully unaware that their windows also previously received sunlight and now they won't. And again, the developer and the representatives of the developer have justified this by saying, but as long as 50% of those windows receive at least 2 hours of sunlight, then that's fine. And
that's the control that applies.
Right.
Thank you. Any panel members, any other questions?
I have no questions.
No questions, thank you. And thank you for your presentation, Mr. Horry.
No, that's fine. Thank you.
Thank you for that. We'll now move to, well, I should just check again. Is Councillor Roberts, has Councillor Roberts turned up, and does he or she wish to say anything? It seems not. So we'll move to the final speaker, which is Mr. Edmund Tang on behalf of the applicant. Mr. Tang, are you there?
Yes, I'm Edmund Tang from DEM Architects, and we have our town planner Nate here, so he will address the panel.
Who's addressing?
Yeah, I'll be doing a presentation on behalf of the applicant.
So you are your name and also
town planner director of Ingham Planning, and I was responsible for preparing the planning reports for the modifications.
Okay, and political donations?
No political donations from me, thanks. I really didn't want to take up time in doing a presentation. The council report has provided a pretty detailed assessment of the proposal. It all derives from the preparation of construction drawings earlier this year. I wasn't involved in the original development application, so I can't comment about the approval of the demolition that occurred in the original development application. This is purely relating to some relatively minor changes arising from preparation of construction drawings. There was more careful attention to amenity, and that resulted in some minor changes to the top floor level on the plans, relocation of a study, relocation or reorientation of the kitchen. They're really essentially minor internal cosmetic changes. The major issue that we confronted was that these days, with complying with the basics and the ADG requiring a 75mm thick insulation in the ceiling and the provision of the services that are required, made the 3-metre floor height in the DA somewhat problematic. We looked at modifying the design without changing the height, and it added quite a lot to the cost of constructing the building, and we also looked at how we could lower the building, but it's so finely tuned with the detention, stormwater arrangements, driveway ramps, etc., and gradients that it just wasn't possible to lower the building. So we've developed this option to get the 2.7-metre floor-to-ceiling height clearances and comply with the BCA and provide all the basics requirements in relation to insulation. So that was the driver of the 300mm overall increase in building height, which is about 2.5%. I'm certainly happy to answer any questions, and if you've got any detailed questions regarding the design, Edmund is on top of that and can provide you information on that aspect. But I'm certainly happy to answer any questions.
Thank you, Mr. Jurovich. Any questions from panel members?
Yes, I have, if I can.
Please.
So when this was approved by the court, the ADG and certainly basics were part of the planning framework. Why have you only just discovered this now?
That's a good question. Typically, 3-metre floor-to-floor height clearances were generally applied and accepted, and buildings were built. But over time, for example, the insulation requirements, in preceding times, the insulation depths were a lot thinner, and now when you've got to do 75mm, it pushes you just above the 3-metre floor-to-floor, and we recommend that that you have at least a 3.05 dimension from floor to floor. But when the original DA was approved, the 3-metre floor-to-floor was considered acceptable and would achieve the compliance with the 2.7-metre floor-to-ceiling clearance. We did look at the alternative, which was to seek a variation for the consent condition, which says 2.7 metres floor-to-floor. You could produce a 2.6-metre floor-to-ceiling, and we wouldn't have to raise the building. But we had a very close look at the implications of increasing the height, and we particularly focused on the solar shadow impacts. And there's virtually no shadow impact on the building to the east arising from the increase in height, and there's an extremely minor shadow impact on the apartments to the west. So on balance, we thought, given that virtually minimal impact, that the amenity benefits of maintaining the 2.7 ceiling were preferable.
Can I add another comment as well? Both Nick and I was not the original team involved in the original DA design. Certainly, my client is inches when he approaches this site with the DA that he want to get on with the construction straight away. And it's certainly not our interest want to come back to council and seek further changes. We checked the project for another 9 months actually. So we work very hard trying to accommodate all the services, structure design, but we just can't get to a point that we just can't meet SEP 65, we can't meet basics, so which is why we're seeking those minor changes.
Okay, I understand. And so what's the reason for the 300 mil increase in the lift overrun?
The original lift overrun allowance was 3.7 from my memory, and we can't find a compliance lift to work. So that's why we work to a minimum, the lift that we can find, and ask for that extra height. Having said that, the whole lift core and the stair core actually move further away from the common boundary. So the impact is negligible, basically.
That was, I mean, one of the reasons we were looking very carefully at the impacts. So with the increase in the lift height, we thought moving it further away from the boundary would then create a net zero effect in terms of streetscape, neighbours, etc. So we're trying to balance every change, we're trying to balance with the impact.
Okay,
I have no further questions. Thank you.
Thank you. Other panel members, any questions? No? All right. So thank you, Mr. Juradovich and Mr. Tang. That, I think, concludes our speakers unless Councillor Roberts has arrived. It's probably a bit late for the councillor to speak anyway. We have now heard from all of the registered speakers, and I thank them all for their assistance with these two matters. In accordance with the panel guidelines, the public meeting will now be closed and the panel will move to a closed meeting to deliberate and vote on each of the matters. The outcomes from the voting and determination will be made available through the council's website, either late tonight or tomorrow, and a recording of this public meeting will also be made available through the council website. I also thank council staff for their assistance with today's meetings, and I declare the meeting closed, the time being 2:07 p.m. Thank you all.